occurred to her that there was an illegal and wrongful intention to secretly detain the deceased at the post the moment no entry was made in the OB. So the third accused is a principal offender within the meaning of Section 21B and C of the Penal Code, and her position is similar to the ones who actually committed the murder against the three deceased. If the third accused had dissociated herself from the other co-accused by some action in order to show that she was not with them in the offense, then her role would have been different. However, she did not dissociate herself from the others. What she did was to deny knowledge of the incident. That does not exonerate her of these offenses. Now, I've considered that an accused person has a right to refuse to give self-incriminating evidence as set out under Article 52(1) of the Constitution. As a general rule, the burden of proof in criminal cases rests with the prosecution, and this is also as provided under Section 107 of the Evidence Act, which states that whoever desires a court to give judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove that those facts exist. Now, if it then follows that if an accused person chooses to hide some facts in order to protect others in court or at large, such an accused cannot be compelled to give such facts, since the burden lies with the prosecution to bring out such facts. The burden only shifts to the accused person under circumstances bringing into operation the provisions of Section 1111 and 119 of the Evidence Act. In this case, the burden shifted to the third accused to explain how the deceased were held at the post while she was on duty without any entry in the OB, how they were placed in the cells and later removed while she had custody of the keys to the cells. Instead of explaining these facts, the third accused decided to deny and also to mislead, feigning ignorance that the deceased were never there, as well as trying to escape culpability by implicating PWA 18 and 2021 as the ones with the keys at the time the deceased were taken to and removed from the post, respectively. Even where the role played by the third accused was that of aiding and abetting, except for the change of terminology, at the end of the day, she is still a principal offender under Section 21B and C of the Penal Code. As for Mr. Gigan's submission that in regard to the pecking order, to obey orders to commit an offense is not a defense, certainly not to murder. It cannot be a defense available to the third accused. In the circumstances of the case, her role was critical, as it was possible for her to thwart the bad intentions of her co-accused just by entering in the OB, the placing of the deceased in the cells, and it was her responsibility to enter the OB if the ones who were expected to do so failed, as she was the one manning the post at the time. Now, for the second accused and the fifth accused, they were principal offenders by virtue of Section 21A, which provides that every person who actually does the act or makes the omission which constitutes the offense, the two of them took an active role in the kidnapping of the deceased, concealing their missing vehicle, detaining them without disclosure, ferrying them to the murder scene, and ferrying them around for each of these purposes. Now, the fifth accused in his statement stated that when they drove the deceased to Soweto open field, the co-conspirators argued for 3 hours whether to kill the deceased or not before they finally took their lives. The fact that they argued, then resolved to continue with their planned intention to take life, does not reduce their actions to anything less than murder. They had a common intention within the meaning of Section 21 of the Penal Code, and I've quoted what it says. So for the second, third, and fifth accused persons, I am satisfied beyond any reasonable doubt that the prosecution has established that the accused persons were principal offenders. They acted with one common intention to commit the offenses charged as explained herein above. The evidence adduced by the prosecution against these three accused, which was largely circumstantial evidence, was sufficient to lead to a conclusion that the accused persons murdered the deceased persons. As to the alibi defense, the second and third accused person put forward, I am satisfied that as to the alibi defense, the second and third accused put forward, I am satisfied that it has not shaken the prosecution evidence that was adduced against them. Now, the other consideration is on the trajectory. This was PW37 was an officer based at the IC3, the Inspector General's Office, Jogoo House, Nairobi. He testified that the IC3 is a center where all the 99 and 112 emergency numbers are received. He testified that the radio exhibit 25 was designed to give a location of its whereabouts. So he was given a request, which he said he now executed. He did a trajectory of the vehicles, which includes the vehicle that was carrying the deceased persons. And that I've already dealt with that, so I'll not go into that. Now, he testified that the investigating officers were also concerned to know whether any police radio phone registered activity within Mavoko locals, particularly in the hours of 1200 hours on 23rd of June 2016. And one radio fitted that description, which was the radio with ICDA number 359033304, which is exhibit 25. Now, PW37 stated that on further query of the serial number, it indicated that the radio phone was captured at Syokimau Police Post at 12:20 hours to 12:40 hours. The radio phone was captured at Mlolongo Police Station between 15:20 hours and 15:40. The radio phone was later captured again at 18:40 hours, between 18:40 hours and 1900 hours at Syokimau Police Post. The radio was captured at isolated field mastermind area called Soweto between 1940 hours and 2000 hours. At around midnight, the radio is captured on the eastern bypass, traveling towards Kangundo Road. It was again captured at Thika Superhighway at 0040 hours, between 0040 hours and 1 o'clock on the 24th of June. This is the same night. And then finally on the 24th, the radio was captured at Valley View Estate between 22:20 hours and 22:40 hours. That radio phone, exhibit 25, according to PW20, the OCS Mlolongo, was IMEA number 864106020019873 and was issued to the in-charge SPIV, Senior Sergeant Leliman, who is the first accused in this case. PW20 testified that every radio has its own charger and that every office had a charger. PW20 testified that he issued the first accused with the radio, exhibit 25, which he received together with its charger. The first accused stated that upon deployment from Athi River Sub-County headquarters in Mlolongo Police Station, following his transfer from Turkana to the region, his boss, who was defense witness number 10, Commissioner of Police, issued him with a firearm, a bulletproof jacket, and a radio phone. The first accused gave its number as police number 559030101 and the IMEA number 864106020310076 and was exhibit that 5. Now, the first accused stated that it was that radio phone that is he and his PIV team used for their work. He explained that he could not have given this radio phone to anyone else except Sergeant Mwangi, as the other officers were from the regular police, that since the fourth accused was proceeding on short leave, he went home with the radio. That on the 23rd of June 2016, the radio was at home. And that on the 24th June 2016, he left the radio charging at Mlolongo Police Station, crime office, when upon switching it on in the morning of 24th, he realized that it had no charge. Mr. Ombeta submitted that the police should have investigated the alibi of defense of the accused, given it was put forward early enough. For that proposition, he relied on the Nigerian case. And then he also he relied on the Kenyan case, Wangombe versus Republic, for the proposition that a prisoner who puts forward an alibi as an answer to a charge does not thereby assume any burden of proving that answer. It is misdirection to refer any burden as resting on the prisoner. In such a case, for the burden of proving his guilt remains throughout on the prosecution. Now, the prosecution has established that on 1st July 2016, when the first accused was arrested, he had the radio phone, which is Exhibit 25. He also acknowledged in his defense evidence that he was actually arrested with that radio phone. As shown above in the evidence of that PW-7, this radio phone, that is Exhibit 25, was captured in all the sites at the various stages in the sequence of the commission of the murders. It was at the posts at Syokimau, post at 12:20 to 12:40, when the deceased persons were delivered there and placed in the cells. It was captured again between 1840 and 1900 at the Syokimau post, the time the deceased persons were removed from the cells for Soweto open field. The radio was captured again between 1940 and 2000 hours at Soweto open field, where the murders took place. At around midnight, it was captured on the eastern bypass traveling towards Kangundo. The radio was captured at the Thika Superhighway at 040 hours, which is the time of the return trip from Oldonyo Sapuk. PW-7 testified that the phone radio signals could be tracked within Nairobi area and towards Thika. The signal tracking ends around Juja, which explains the lack of tracking beyond Juja, both for the trip towards and trip from Kilimambogo. Now, under Section 111, subsection 1 of the Evidence Act, the first accused to discharge a rebuttable presumption by offering a reasonable explanation about the radio phone Exhibit 29, which was tracked in all the lock-in quo, and 9 days later was actually found with him. I have considered the sworn testimony of the first accused. He stated that upon deployment from Athi River sub-county towards to Mlolongo area police station, following his transfer from Turkana, his boss, who was PW-10, issued him with a firearm, bulletproof jacket, and a radio phone. Now, the first accused gave its number as police number 55903101, and IMEA, which is Exhibit 35. Now, the first accused stated that it was that radio phone that he and his PIP team used for their work. He explained that he could not have given this phone, radio phone, to anyone else except Sergeant Mwangi, as the other officers were from regular police. That since the fourth accused was proceeding on short leave, he went home with the phone. That on the 23rd, it was at his home. That on the 24th of June 2016, he left the radio phone charging at Mlolongo Police Station Crime Office. When upon switching it on, he found that it had no charge. That is on the morning of 24th. The first accused was arrested on the 1st of July, carrying the phone Exhibit 25. When asked how come he had it, yet his evidence was that it was never used 24th, and that he proceeded to Makindu police station, but on the return, he could not find it. So he grabbed the one that he found charging, which happened to be Exhibit 25. Now, what the first accused needed to give was a plausible and reasonable explanation of how he came to be found with P Exhibit 25, which had been to all the lock and quo of this case, and yet he insisted the radio phone was not the one that had been issued to his team. His explanation is incredible for reasons. One, PW34, the county commissioner, the county communications officer in Machakos, testified that on the 26th of April 2016, he issued new pocket phones to Athi River Division, which was to start using the new system of radios covering Nairobi area. His PW34 testified that he indicated who should receive which specific radios. In Mlolongo, he said the specific pocket phones that each officer, that is the OCS, his deputy, and his PIF team, and the CID section, and Syokimau police post were to be issued with, as per his register, which was Exhibit 73A. 2. PW20, the OCS Mlolongo, confirmed that the first accused received the radio allocated to PIF team, which was Exhibit 25. And then 3, the radio Exhibit 36 had no data, and PW37 testified that the reason for no data was because it was never used at any one time. Indeed, PW44 and 45 and other team and their team recovered it. At the time that they recovered it, it was in the house of the fourth accused. The radio was neatly packed in its box, complete with its wrappings and the nylon film used to protect the screen when it is new. It is therefore not true that the first accused, what the first accused said, that he and his PIF team used that gadget for their work. Now, 4, after being in each of the 5 sites or lock and quo of the murders, the radio, which is Exhibit 25, was captured at Valley View Estate between 22:20 and 22:40 hours on the night of 23rd and 24th June 2016. Now, Valley View Estate is where the first accused, the house of the first accused was. So where he lived with his family at the time. And then 5, the first accused was carrying the radio, Exhibit 25, on the 1st of July 2016, when he was arrested at Flying Squad offices where he had been summoned. And lastly, since the first accused said that he was the one who had the radio, Exhibit 36, on the morning of 24th of June 2016, when he left it charging in the office, how did it get to the house of the fourth accused? In its box, wrapped as new, complete with the protective film on the screen, and yet the fourth accused was away between the night of 22nd of June and 27th of June 2016. How did it get to the house of the fourth accused? Now, the evidence of the police radio phone trajectory detailing the movement of the radio P Exhibit 25 on the 23rd of June and the evidence of its recovery from the first accused 9 days later all show that the first accused, as in charge of SPIV and in line with the accountability protocol of accountable gadgets like police radio phones, had custody of the radio phone and had used it exclusively at all the 5 lock and quo at the time the offenses were committed. The prosecution proved that the radio issued to the first accused by defense witness number 10 was never put to use. So I find that as the radio indicated, the first accused was at the Mlolongo police station on the 23rd of June 2016. He proceeded to Mavoko Locals, then to Syokimau Post, to Soweto later that evening, where the deceased were all murdered, and to Klimambogo through the Kasupa Highway to dump the bodies of the 3 deceased persons before returning to fetch his co-accused at his bar in Mlolongo for work well done. Now, I considered the first accused defense, the evidence of his witnesses. I find that the prosecution has established that it is the first accused who had the motive to harm the second deceased in this case, because as a result of the complaint he made against him at IPOA, his job was on the line. The first accused may have gone to Uhuru Camp to help his sister-in-law in the morning of the 23rd. However, from then on, the evidence is overwhelming that he personally attended to ensure that the deceased persons were captured, they were detained to await nightfall, murdered, and their bodies dumped or flung into the river to make it difficult to ever recover them. His explanation about the radiophone, Exhibit 25, just as his alibi defense, is unreasonable, incredible, and is not plausible, and therefore I reject it in total. I have carefully considered the entire evidence adduced in this case by both sides, and I have considered the submissions by counsel, the authorities relied upon, and having done so, I find that the circumstantial evidence established against the first, second, third, and fifth accused persons justify the drawing of an inference of guilt to the exclusion of any other reasonable hypothesis except that of guilt. I considered whether there were coexisting circumstances that could weaken the chain of the circumstances relied upon, and found none. I am satisfied that there was no other reasonable hypothesis that can be made on the basis of the evidence before me except that of guilt. In the result, I find that for the fourth accused, his alibi defense has shaken the veracity of the evidence of the prosecution against him, being that of the fifth accused alone, and therefore I gave him the benefit of the doubt and acquit him of all the 3 counts of murder under Section 322 of the Criminal Procedure Code. For the first, second, third, and fifth accused, I'm satisfied the prosecution has proved the case against them beyond any reasonable doubt, and therefore I found them guilty of the 3 counts of murder, contra Section 203 of the Penal Code. I accordingly reject their defenses, find them guilty as charged, and convict them accordingly under Section 322 of the Criminal Procedure Code. Now, I also want to inform the first, second, third, and the fifth accused persons that they have a right of appeal within 14 days from today. And before I end, 2 things. I wish to register my gratitude to the Learned Prosecution Counsel, the Learned Counsels for the defense, and the Learned Counsels for the victims and the interested parties. And I thank you very much for your great support, your industry, and contribution to jurisprudence, and also for giving me an opportunity to complete this case. And I also thank the accused persons for allowing me to complete the case. At the beginning, it didn't look like it was going to happen. Now, I wish to end with a little story. There's a man who told his son that he wanted to teach him a new trade. So he asked him to follow him. They went to the neighbor's farm and stood next to a mango tree. The father told the son to look around as he climbed up to pluck some mangoes. He told him that his role was to look around, and if he saw anyone at all, to start running home, and his father would follow him to avoid arrest. So the young old man climbed the tree. After 5 or so minutes, the father saw his son running, so he climbed down quickly and followed him. After running for some time and seeing no one following them, the father stopped his son and asked him why he ran, telling him that he did not follow his instructions. So the son said, "No, but I did follow your instructions. I looked up and I saw God looking down on us, so I ran away." So that is the end. Now,
before sentencing, we should be on record.
now I'm totally funked as official. I want to make only one order. To take this, to have this file placed before the presiding judge criminal, so that you proceed with the other things. What did you want to say?
Obviously, before the sentencing, we wanted to inform the court that the 4 accused persons are personal witnesses.
No.
But we'll do it before the other court.
Not even that. I think we also need to have victim statements,
yes,
victim impact statements and things like that.
And of course, we wanted to request whether there can be also confession of charge of court before the sentencing.
Tell them to stand.
Ladyship, we request to be an issue that you've raised. Your Ladyship has said that your predisposition is that the other aspects, including sentencing, should go probably to another judge. On behalf of the third accused, your Ladyship, we would have preferred that you complete the process. Yes, we want to be on record as saying that, your Ladyship.
I thought you said I'm coram non judice.
I need to be taking the same position with my learned colleague, because again, also having had your judgment and another judge coming in to give the sentence, putting into consideration that you said the second accused person gave unsworn evidence, yet we know clearly that he gave sworn evidence. How will that be handled? He gave sworn evidence, he was cross-examined. In your ruling, the whole judgment is that he gave an unsworn statement. From this particular point onwards, you can see why we want to appeal and why we're having a problem with the judgment.
I don't know what you are saying. What are you saying? Are you saying I hear this, I do the sentence, or are you saying...
Yes, you let us go on to the end, because you see, the moment you have said that my client gave unsworn evidence, yet we all know that he gave sworn evidence and he was cross-examined. That puts us in a position whereby, first of all, we are saying that probably the new judge who comes in to do the sentencing must look at that as well. You having then given the judgment with this very serious omission or problem that you have created, do you shift this burden to another judge, or do you do it by yourself? Because for me, it is pretty serious that you did then not get the evidence of a second accused person you have convicted in, yet he gave sworn evidence. It was cross-examined by everybody, but according to your record, it was unsworn. How did this come about? So these are issues that we will raise, probably maybe even with the next judge, but I'd rather that you are there so that we can throw these rocks at you.
Your Ladyship, the whole idea was mine. I just want to dissociate myself from what Cliff has said, Your Ladyship. Your Ladyship, my point is this, Your Ladyship. I'm not taking the same militant position as Cliff is taking. My point is this, Your Ladyship. Sentencing is the point at which a judge is most subjective. It is the point at which the judge is applying consideration of all the issues that are obtained since the start of the case. And for that reason, Your Ladyship, if there was any role you would have played, it is more at sentencing than at any other point. And for that reason, Your Ladyship, I'm making more informal request, Your Ladyship, that you do, having come this far, that you do entertain the process up to the point of sentencing.
No, but somebody wants to throw things at me, so why do I want to sit around to wait for missiles to be thrown?
But who else can do that? You see?
Now I think, let's hear Mr. Michuki.
Yes, because even when you place the radio in the second accused's hands and you read it in your judgment, we have a problem, don't we?
Your Ladyship, just 2 points. First, I'd like to associate myself with my senior, Mr. Carter. I think sentencing is an exercise of discretion, which you have to take a number of factors, and a new judge does not have a grasp of this matter to really sentence the accused persons or not the convicted persons. Secondly, my lady regards to the secure indulgence that he continues being held at Naivasha under the protective circumstances. He has been held since he took plea in this matter. Yes, separating from the other accused persons has always been the case. Lastly, and off the record, given that my liberation falls squarely upon you, my lady, I would wish for you to proceed. Please.
I thought you are the one who is very sure I'm coram non judice.
Your lady, you've already assumed jurisdiction. I'll follow your decision. We cannot give any other issues on appeal.
Your Ladyship, on behalf of the court accused, we can only say thank you. It has been a long journey.
My lady, on behalf of the MSK and of course the victims, sorry, some chair.
Yes, on behalf of the fourth accused, we are also requesting that his mobile phone unit has been found, be restored to him. And also, on behalf of the first accused, only for Plan and Council, Mr. Clip, or better, is requesting that his car be released.
Who's car?
The first accused car.
There was a motor vehicle that was used as an exhibit that was detained. We had that argument and the state had said that they wanted to vote on it. You had made a decision that you would, at the end of the trial, make a decision about it. There was a motor vehicle that was used as an exhibit. It was KB 959 something. Yeah. It's so long we have not forgotten about it. But it's in the court.
I don't know what I'm releasing. Does it have an exhibit number?
I know it's a KBF 959H. It was a Winroad Nissan. KCG 959H. It was a Nissan Winroad white in color. No, silver color.
That's not the one you released to the wife of the first accused. It's not the one.
Nothing was released.
K what?
KCG 959H.
Yes. Anyone else? Just 1 minute. Just 1 minute.
Family and advice. Let's try. We would also wish to file a victim impact assessment, 39C of the CPC, and we are seeking 14 days and we finished in that 8:30.
So when you say Law Society, how many statements am I going to get or will be filed? You are saying the entire Law Society, so I don't know how many statements.
It will be just 2 statements, but covering victims in and victims in terms of the family.
Yeah, because I wanted to adjourn, but other people have now said other things.
Yes, now that we proceeded, allow me to say this first of all, that the 4 accused persons, 1, 2, 3, and the 5th, we have no previous records of conviction.
We are not taking any mitigation at this stage.
Okay, I'll say that later. Then, really, my view is that a court that convicts is the most appropriate sentence. And we require 2 weeks to have the statement, that is the impact statement. We have filed only 3 in relation to the deceased persons put in place for your consideration. We also urge you to exercise your discretion and order for progression of that report in respect of the 4 accused persons to be filed and shared with the prosecution before the sentence is closed. These are our 2 prayers today. The issue has been raised by a motor vehicle, which was produced by the prosecution, which belonged to the spouse of the first accused. And the motor vehicle that was used to ferry the deceased person's bodies to the damage. Really, we have not come to the conclusion of this matter. We only have a conviction, and it would be premature, my understanding and the interpretation of the law, to come to this matter now. But when we come to it, we want to address ourselves substantially, because as you indicated when there was an attempt with the use of the motor vehicle, we did indicate that this was an instrument of crime which is subject to oppression, which are auxiliary orders of court. So I don't want to go into it.
You are saying subject of what?
Oppression. And I don't want to go into this because we want, after the conclusion of this matter, to address the issues of science where we have. And if need be, we file our submissions in the matter. in respect of the peace. That is all.
My lady, in this motor vehicle, we had a problem about it. Initially, at the close of the prosecution case, and then after the defense case, and now a creation is being made that is subject to forfeiture. That does not exist on any law.
No, you know, I'm not.
My lady, the only thing that exists on forfeiture is known. It's either things to do with drugs and lots of. In murder cases, let him not create this law. It's not there. Let him just release motor vehicle. I don't know what interest they have on this motor vehicle on the 3 stages that we made this application. It does not exist. If it does not exist, then your leadership can't even give you time to make an application about it. It doesn't exist.
No, I'll not consider that one for now. I think if their indication is they want to make submissions, then we can hear, but both sides can be heard. Yes.
Your Leadership, I just wanted to seek a copy of the judgment of the court for now. To go on record that we get approval. Your Leadership, you know, and the proceedings certified for purposes of appeal.
The proceedings are there. I thought you have been getting all of them.
They're not certified, Your Leadership.
Now I'm funked as official. You will talk to the DR. So is this?
Your Ladyship, we have a request also for the third accused. Your Ladyship, in view of what the prosecution has said and the victims, Your Ladyship, we would pray that the victim impact reports, Your Ladyship, be designed in a way to make reference to specific accused persons, Your Ladyship, rather than general quotation on the part of the victims, Your Ladyship. And we still plead with you not to step out, Your Ladyship.
No, I think I've had enough. I should just step out of this matter. Don't you think? Now, do you want to give a written mitigation?